We are now live on Facebook. Two Speckies. We've got the same glasses almost, Damian.
Oh, yeah, haven't we?
We're very, very similar. Obviously, very, very...
and I'm nearly as brown as you now as well. I've been in the sun today, so...
Well, almost.
Am I allowed to say that because I'm not a mere?
I don't know. Some people get upset when you make jokes about that, but I'm all good.
Oh, well, there's more jokes coming. No, not tonight. This is GDPR night tonight.
I know. This is we can try and make it fun. We can try and make it fun. So, so I've got Damian here. So I'll give you some background. There's something called GDPR, which is coming into place in a few days' time. I believe 2 days' time or something, and that's why we've all probably been getting a bunch of messages from people around. Please update your details. Please update your settings. You might have seen stuff around, and for a long time I kind of buried my head and was like, oh, put it on the bottom of my to-do list, it'll go away. And obviously it hasn't. And I watched a webinar on it a few weeks ago, and my takeaway from it is it's not that bad. It's nothing to get worried about. Don't bury your head. And to be fair, Damian and I haven't spoken about this, but I saw that you were putting something out around GDPR and helping coaches with it and help people understand what it means. So even though I don't know what you're going to say, I thought it would be useful just to get your viewpoint on here, and we'll do the little disclaimer. I know you're going to do your own disclaimer. My disclaimer is I'm not a legal expert. This is not considered professional advice. If you really want to know what's what, go and consult a lawyer. Go and get your own professional advice for your business. Please consider this for entertainment purposes. And these are just our opinions.
And even that's a loose one.
Even that, yeah. Even we're not guaranteeing that you'll find this entertaining. So that's kind of the disclaimer up front. But I thought it'd be useful, maybe Damian, if you want to give your disclaimer and a bit of background, and then we can just maybe talk about what you see GDPR is, how it applies to coaches. And then, as always, I want to open this up to questions that we might have from the group of, people who've got specific questions around what it might mean for them.
Okay, so my disclaimer is, as I also put on my website, is I am not a lawyer and I am not legally representing the views of the European Union. And basically, even if you go to a lawyer, you will get different views. If you go to a lawyer in the Netherlands, you will get different views to one in Ireland and London. So even they don't know what's going to happen. So the whole thing about GDPR, which is really interesting, well, a couple of things. First of all, is that it's already law, right? People don't even know that. It's just that the enforcement takes place on the 25th of May. But people don't even know what's going to happen. And it is like Y2K, as we were talking beforehand. So no one actually knows what's going to happen. But of course, the scaremongering is the bit that people are talking about. It's like, 4% of earnings and 20 million pound fines, whatever it is. It's like, for most coaches and consultants, right, you are under the radar for that. So first of all, there's nothing to worry about as long as you are being sensible, and that's really the point about the whole GDPR thing, which, by the way, stands for God Almighty. Data Personal Responsibility. It doesn't really. It stands for General Data Protection Regulation, but it might as well stand for God Almighty Data Personal Responsibility, because that's the way people are really scared about it. And essentially, as long as you are being, this is been in effect already. The way you handle data is already a sensitive thing. It's just contract based. But the only thing that the GDPR regulations are doing is turning it into law and contracts. That's it, right? So it's becoming law. It just means that you can be sued, and you can be sued. You can be sued personally, and you can be sued by the regulators. So, and this is where people are getting scared, but people are doing crazy stuff. People are, saying that people are going out of business because of it, and they're hiring 10 grand consultants and all this stuff. You don't need to do that. So the reason I actually even know anything about this is because I run mastermind groups, and I've got a number of different clients, all entrepreneurs, mostly clients who are coaches and consultants. Actually, that's not true. I'd say about 25% are coaches and consultants, and the rest, run different sorts of businesses. And they all asked me about this not that long ago. And as someone that was serving them, I thought, well, I better go and find out about this, because my first response was, oh, I don't think it's that much of a problem, because that's what I'd heard from people around me. So I thought, well, rather than actually give that as advice, I better go and actually do some research on it. And as a result, I ended up creating a one-page document, which I will send you guys the link to, which kind of takes a little bit of the sting out of the tail. And I've turned it into an acronym which is fairly sensible, which is abracadabra. And basically, GDPR, if you think about it in the right way, is actually an opportunity. It's an opportunity, and we'll talk about that in a minute. But in terms of actually what it is, it's the legal enforcement that's coming into place on the 25th of May. Nothing's going to happen. The world is not going to, there's no sinkholes are going to open up and swallow you. But if you're even relevant, even if you're thinking about, if you're looking at this podcast, it's because you have some sort of interest in GDPR. The people that are going to be in trouble are the ones that are sticking their head in the sand and abusing the data. And they're going to be the ones who are big businesses that are doing it on a big scale as well. Medical records, credit card details, tens of thousands of people, losing data in the backs of cabs, that sort of stuff. And this is what's been happening, and this is why the news of like Cambridge Analytics and Facebook this is why people are getting scared about it, because these are big businesses that are using data in the wrong way. And the only thing that's coming on the 25th of May is the law, the actual, the making the law so you can actually go to jail, which you can't, but they'll fine you, and if you can't pay the fines, you could. But it's scaremongering. So as coaches and consultants, if you're in McKinsey and you're like one of the senior people in McKinsey and you're watching this, what are you doing? Because you should have someone that's looking at this already. But I think for coaches that are small business owners and self-employed, as long as you are sensible about it, because basically this is about trust. This is what it's about. It's about taking people's data, and it's about using it in a way that is trustworthy, transparent, and that you can be accountable for. So you need a data trail, you need an audit, but we'll go into a bit more detail on that.
So thanks for that. And we've got a few people watching. Hi Alfredo, hi Helen. Anyone else online, feel free to say hello. So you say this is law, and I've heard a few people say this already. Like, this is already law; it's just becoming enforceable. So kind of what are the high levels? Because my understanding was really, with regards to personal data, I remember from my marketing days, some people would they'd take it kind of dodgily, they'd take your email address and they'd add it to a list. I've had that happen to me. I've not signed up to people's lists, and next thing I know, I'm on their mailing list, right? Which I hate, and I never do to anyone else. So my understanding is it now that they're kind of just cracking down on that? So if you've got someone's personal data, they've had to give you the permission to have it. Like, is that one of the crux?
Yeah.
And basically you've got to have a reason for having it.
Yes. Yeah, so if you've got, one of the ways that people are saying they can get out of it is if they've got legitimate interest. So if you have, now what you're talking about there is people basically buying lists. Now, there's this whole thing about B2C and B2B. Well, the whole of the GDPR is basically talking about human beings, right? Now, human beings are in companies, so that data of those people is what we're talking about. Yeah, so we're not talking about companies per se. We're talking about the people within the company. So, and that person in that company can come and sue you if you've got their details and you're using it illegally, which is basically what it will be, is illegally, and you are contacting them without their permission. And after the 25th of May, there's a number of things that you have to be able to do, right? You need to be able to give them the option to change it or delete it. And you need to do that within a time frame of 1 month. You need to actually, if you keep their data, you need to have a legitimate interest, right? So if, for instance, you've taken it from a list and you bought that list and they haven't double opted in to that list, then after the 25th of May, essentially that data is useless for you.
What does double opt-in mean, just so we can get
it basically means that they have agreed that they want to be on that list. right? So, but there's other things as well. So it's not just about having double opt-ins. It's about, you need to actually have a list of people that, and this is why what we're going to go on to is this is an opportunity to clean your list. That's the whole point about GDPR, which people are missing. It's a massive opportunity to actually cleanse your data, because you'll be sending emails out to a bunch of people that really aren't interested in it. Well, use this as an opportunity to actually find the ones that have high engagement. Okay, so if that data was collected but it didn't have a privacy notice, a data privacy notice, and most people don't do that, right? If it didn't have a notice saying that you have a right to change or delete your data, or if it didn't have even somewhere that you can make a complaint or unsubscribe from, then technically that is not GDPR compliant. So after the 25th of May, and again, you're flying under the radar here. We're not talking about, it's big businesses that the regulators are going to be going after, but this is an opportunity for you to get in contact with your list and say, and maybe even do it after the 25th of May. It's not a problem. As long as you are showing that you are making steps to be compliant, they're not going to come after you, right? So if you email them in 2 weeks' time and say, look, the reason I'm emailing you now is because you'd have already had all the GDPR stuff. However, the reason I'm emailing you now is because I really need to know whether you want to stay engaged with the list, and be creative about it. Because and what I found is, and I've got a number of clients who are using this as an opportunity, we are ranging from 25% engagement, so in other words, putting your list down to a quarter, to 85%, which is the highest I've seen, which is that basically only 15% of people are not choosing to opt in. But even then, there's a little bit of, actually, are you putting an opt-in button, or are you just saying, if you don't do anything, I'm going to keep you on the list? So even then, people are unsure about what it is actually to be GDPR compliant. Now, that all comes back to how you collected the data in the first place. So if you have the data privacy notice, if you have the right to rectify the accounts and delete it, if you have who you can make a complaint to, and depending on who your host was, if it's something like GoDaddy, they haven't really been on this very, very, or HostGate or HostGate or whatever it is. They haven't actually been on this. They're only starting to put this stuff out there. But MailChimp have been pretty good with this. So it depends who your server provider is, and whether you've had these notices on there or not. So the basic thing is, it depends. But for most coaches and consultants, you're under the radar. They're not going to come after you. So it's about using this as an opportunity for engagement.
Okay, so what I've been doing is, in essence, I know I'm with MailChimp, and they've got kind of a walkthrough about to go in and get the opt-in. And you're right, I'm quite lucky in a way that I've got very small lists, and I've probably got, I don't send out too much stuff, so I've just kind of gotten back and said, look, if you don't opt in, I'm going to delete you after this date, and it doesn't make that much of a difference to my business. And like you say, it's an opportunity to cleanse my data. And what do I really need to hold? What do I not need to hold? And be sensible about it. So let's say I've done that. And by the way, if anyone's got any questions, please ask, and we'll cover them. And don't worry, we can go back if we move on. But you've got a question about something. So let's say I've done that. Let's say I've gone out. I've kind of deleted the people that haven't opted in again. I've cleaned that out. I've cleaned out my personal data that I hold on people in my business. Then what do I have to go and tell someone? So what do we have to tell the ICO, the Information Commissioner's Office? You've got to let them know or not, or
nope.
What happens there? You
just got to show that you're being responsible. That's it. Okay. So you've got to have an audit of obviously what you've done. And what you're doing. So if you're holding medical records, if you're holding credit card details, you need to have people in your business who are trained to look after that data. In the same way that if you had a knife shop, you'd have people that were trained with health and safety. It's just obvious. It's common sense. So it all depends on the risk of the data. So this comes back to, again, what sort of data are you asking for? So, for instance, if you're a company that doesn't need credit card details, but you're asking for credit card details, as, let's say, proof of age, you're into dangerous territory, right? Because why are you asking for credit card details as proof of age? Yeah. So, and where are you holding that data? Is there a contract based? What are you doing with that data after the contract's finished? It's all about being sensible with the data. It's common sense. So, if you could show a legitimate interest for having that credit card data, in other words, if they were buying something like postage and packaging, makes sense, right? Little things that you could put, which is an obvious thing because then you're turning it into lead bait, yeah? So, or a tripwire. So you're putting something in your funnel, which basically someone has to buy, so it turns them into a customer, right? You're getting the credit card details for legitimate interest. Well, you turn them into a customer, it changes the trust of the conversation. So that's legitimate, right? If you're getting credit card details as a proof of age, that's not legitimate. So you've got to think about what you're doing. But again, we're talking about very small numbers here. We're not talking about. But then you've got to be a little bit careful because someone comes back to you and says, look, and this could be the new PPI in a few years' time. Why did you take my credit card details? Yeah. We didn't do business. Why did you take my credit card details? It could open up the floodgates in years to come. Now, again, as long as you've got an audit, as long as you've got a trail, as long as you've got, for instance, training going on for, they talk about data protection officers. That tends to be for bigger companies that have to deal with large amounts of data. So it's about being sensible. It's about being transparent. It's about being sensible. And essentially, it's about deepening digital trust. That's really what this is about. For business owners and for coaches and consultants, it's about deepening digital trust. So you should be using it as a positive thing in your business, because it's all very well to go sending out masses of emails to huge lists, but the only emails that are relevant are the ones where you get engagement anyway. So why not have a list that's highly engaged, that has a deeper digital trust with you, and there's less people to focus on, isn't there? So it just makes sense. It's a really simple thing, and I think people are getting a real bee in their bonnet about it being like, as you say, like a Y2K thing. And it's not. It really isn't. It really isn't. You're not going to get sued.
Okay. And again, I will reiterate, I don't know that, so I'm not going to... I know that's Damian's kind of opinion, and I just want to kind of reiterate that. And these are just our opinions around
but if you actually show, if you have an audit and showing that you are making... if you are trying to adhere to the GDPR guidelines. I mean, they've even stated this. It's like if you show that you've been doing it, it's for people that have been burying their heads in the sand and been ignoring it and breaching it, blatantly. They're the ones that are going to be in trouble.
So I would assume most coaches, the kind of personal data they're going to hold on clients are going to be names, email addresses, maybe physical addresses when they're sending stuff out to their clients or former clients. What constitutes? So here's a question for you: what constitutes legitimate interest? So, for example, if I had a client 5 years ago, and I sent them something, and I've got their address on a file or on a coaching agreement, but we're no longer working together, is that stuff now I need to get rid of? Is that something I need to, have a reason to keep? Because maybe potentially someone can go back and say, well, you breached our agreement, so I need to have a copy of that agreement. It seems to be a bit open, if you like.
Yeah.
Where's the line on these things?
It all comes down, and this is the question I get asked the most. It's like, with the data that you have, what do you do with it? And it all comes back down to, is it GDPR compliant now? And if not, you need to get that compliance, right? So the whole thing about legitimate interest is people are talking about that as having that as a backup. Well, is that true? If you had a client 5 years ago and you still got their data and it didn't have a data privacy notice, it didn't have within the contract, you can change this data and you can delete this data and this is the person to speak to, it's not GDPR compliant. In which case, why have you still got it? Now, there's a number of things around this. You say, well, what are you doing with that data? If you are just sending them something in the post as a reminder, it's probably okay, right? If you are selling that data on to a third party, it's not okay. It's common sense. So what are you doing with that data? It really is common sense. So I think this is where people are actually getting in scaremongering, because they're saying, oh, I could get a fine if I still have this one email address or this one address and I haven't. It's like, no, that's not going to happen, right? There are bigger fish to fry in respect of, the fines that we're talking about. They are the Cambridge Analytics, they are the Facebooks, they are the bigger corporations. But there are companies that will have 300 employees. They'll have a database of 10 or 20,000 people, and they'll be doing pretty bad stuff with that data, or they just won't be looking after it in the right way. They're the ones who are going to be in trouble. If they've been burying their heads in the sand, they don't have a data protection officer, they don't have training involved, they haven't gone back to the list and said, look, we didn't get you in the right way, but this is what we're going to do now. It's about common sense. It is basically about common sense.
Okay. So, if we've got any questions, I mean, this sounds relatively straightforward. Damian, you've got a one sheet that you can share with us, which covers a lot of stuff. But I'm really curious. We've got a few people watching. Do you guys have any questions? I'm assuming, Damian, that most of the coaches that are in this group and most of the people that are watching it or will watch this are kind of one-man band or one-woman band. Let's be politically correct. Kind of businesses. It tends to be just them that run the business, and like you said, they're probably going to have name and emails, and maybe some postal addresses, and that's it. But I'm really curious to hear from people. One question I've got for you, Damian, is we've seen people's computers get hacked. We've seen Twitter and Facebook and whatever get hacked. This group is obviously on Facebook. Let's say you connect with some clients on Facebook. You're exchanging conversations. Maybe you're even coaching people over Facebook, and your Facebook gets hacked, and someone gets access to that data. Could you then get fined for that? I mean, that seems a bit. I've heard someone say that, and I thought that surely can't be right. What's your view on that?
No. So what is that data? How is it collected, and where is it?
So if it was on kind of Facebook Messenger, because I'm saying this because we're on Facebook. So let's say someone. Well, let's say me. I contact a client on Facebook. Went, great coaching session. Very sorry to hear about the death of your father. Whatever. It's personal information, but we're just sending that. It's very clear that we're having that coaching conversation on Facebook. Look forward to speaking to you again in 2 weeks' time or whatever. Now, that could be something sensitive that they don't want anyone else to know. They don't want anyone else to hear. We've got a client relationship. Sometimes I'll send someone a little audio clip on Facebook Messenger. Let's say they've asked me a question. I'll go, well, this is what I would say to you. So that's obviously kind of private information they wouldn't want to be shared in the general public, in the personal domain. But let's say
it's about names, addresses, email addresses, credit card details. It's not relevant.
It's not, because I heard someone say even coaching notes comes under this regulation. Anything that describes it, anything that's private information. So,
if it was attached to a file which had their name, address, email address, phone number, yeah.
But
because it becomes sensitive records then. Yeah. So medical records as an example. Yeah, it becomes sensitive records, but it's all about, you have to have their name and email address to start with.
So on Facebook, you have someone's name, but you don't have someone's email address. Therefore, because I've heard someone else say that no, that is definitely covered. Is that, in your opinion, not the case?
No.
Okay. We've got a question from Christine. Christine says, "Hi, what happens if I haven't contacted my list before the 25th?"
Well, as I said, I actually think that's a really good reason to do it afterwards. It's like, people sending Christmas cards in the middle of January and Easter cards in the end of April. It's actually going to set you aside from your competition. Now, there is going to be a hell of a lot of a hullabaloo after 25th of May, and it's all going to die down very quickly because it will be the big companies they'll be going after. And if you've shown that you're aiming towards being compliant, you've got an audit, then you should be fine. I don't think that's going to be a problem at all. It depends on the size of your list. If you're talking about 25,000 person list, I would be concerned. If you're talking about a couple of hundred, I really wouldn't worry. But again, it's how did you get that list? The biggest problem I see is for people that have bought in a lot of data and are using it essentially to spam. You see, this is the problem about buying in a lot of data. You're buying it in cold. You're getting it from a data source which is, okay, essentially they've shared their information with a marketing company, for instance, and you bought in that data. But to make that data valuable to you anyway, you're going to need to get engagement with it. Yeah, so you're going to need to actually engage with that list. This is an opportunity to do that. Now, this is me giving coaching advice here. As we build up, and this is something I'm actually doing, I'm sending GDPR emails after the deadline. And there's a very good reason for that, because I'm actually waiting for the influx and everybody to get it. And then I'm actually going to send an email after the deadline saying this is why I'm sending it after the deadline. It's more likely to get opened. Yeah, and the reason I'm actually doing that is because I want to get more engagement. I want to get more people opening it and more people actually going, do you know what? That's actually sensible. So it's about engagement. So don't worry about the 20. Yeah, it's already law. This is the whole point. It's the enforcement of it. As I said, the enforcement of it doesn't really apply to us guys. It applies to the big guys.
Unless you're doing something really stupid, spammy, sending it out, selling it. Anyway. Yeah, which you shouldn't be doing in the first place.
Why would you do that?
So Christine said, I've had some people just updating privacy policies and others that are asking me to re-opt in. Which one do I need to do?
You need to do both. So it depends if you've actually had that double opt-in. If you've had a list that has had a double opt-in, you need to check whether there was a data privacy notice that was available as part of that double opt-in. Now, as I say, MailChimp have actually been quite good with this. GoDaddy hasn't been very good. So you need to actually check with your service provider and see whether when they became GDPR compliant. Now, as I say, MailChimp did fairly early. But I know GoDaddy didn't, so it depends on who you're using.
So that's a good question around privacy. So I've got a little bit confused about this, right? I don't have a privacy policy on my website. Mm-hmm. I've never had one. I just had a quick look at your website before we went live. I couldn't see a privacy policy. Do you need to have a privacy policy listed on your website?
No, it just needs to be in your email when they sign up.
Okay.
Yeah.
And all right, so I just use a standard MailChimp one. They have something that kind of covers this within that, or do I need to have something specific?
No, use the MailChimp one. I mean, it's all part of their service. I mean, I would you do. There's the whole thing about cookies, where that's part of it. It's good. It's a good thing to have a cookies policy. Yeah. So, but no, it's when they give you data. You don't need this on your website. It's when they give you data that you need these. Yeah. Because you're basically exchanging. You're having an exchange. They're giving you data. You're giving them something in return. You're basically giving them your trust. That's what this is the whole point about this. Deepening digital trust. That's the way to really think about it. It's like, is this deepening digital trust?
You know what? As I'm listening to you, Damian, I'm really liking this because actually you're right. This is not a bad thing. This is about, because I used to see this, like for people just joining us. I've had people who have had my email address for some reason. We've contacted each other, and next thing I'm on their list. It's happened a few times, and I've often not just said anything. I've kind of like, oh, that's kind of not right. But what this is doing is stopping that or trying to cut it out. And so if you're doing that in the first place, I would advise you don't want to do that because you don't build a real solid relationship. People don't like being, it's the same reason why people don't like being added to Facebook groups without their permission. I've had people do that to me before. And it really comes from, I would say, this needy, desperate place to get clients or to grow big lists or whatever in the first place. And like Damian, you said earlier today on this call, which I really liked, is, what's the point of having a big list or a big list of contacts or even a big Facebook group if nobody's engaged? So I think this just reinforces maybe what we'd call good practice, maybe what I'd call, heart-centered approach with coaching. Coaching to me is a real deep relationship business, and that starts all the way through in everything that you do. So, if you're not, caring about people that are working with you or potentially working with you, then chances are you're not going to be very successful anyway. This is just clamping down on it sounds like the worst excesses.
Mhm.
Christine saying, if you use a calendar or scheduler, then you need to post a privacy policy before they give details. Is that right?
If you've got, I've got Acuity, and you need to sign up for that. So yes, you do.
I just use Google Calendar, and I ask people for their email address so I can pop it into Google Calendar. I don't do anything else with their email address. I don't add it to my list. I don't use it for anything. Would I need to now start getting permission before I ask them for their email address?
If you're not using it for anything, it's fine.
Just to send the confirmation of the...
Yeah, this is one of the other grey areas, and this is why there's going to be so much fallout from this for the bigger companies. What is processing data? Right now, in terms of like you and I, right, we are so under the radar that it would be like, well, if you have an email address, so because if someone gives you a business card, right, is that processing data? Now, for the lawyers, and this is where really they're going to have a field day with this, they are already arguing about, is looking at someone's email address on a business card processing data? And this is the level that we're talking about, that we don't have to worry about, because this is the level of arguments. We're talking about different European countries having different ideas on what that means in different languages. And this is going to go on for years. Seriously, one of my friends is actually working on a GDPR compliance policy for a global corporation and has been doing this for years. And even he says, we are so far away from seeing a small business even getting looked at because of all of the fallout from this. You know, this whole thing about age of consent. Well, in different European countries, there's different ages. And in this country, it's going to change. So, but we're also coming out of the European Union. It's like there is, honestly, the legal battles are going to be, they're going to be raging for years. So in some countries, just literally looking at a screen with that data on it is considered processing data, because as far as they're concerned, you have that data. Well, the lawyers are going to be arguing about that. Is that digital? Because, you know, all of a sudden you're just looking at it and you've remembered it. So it's about best practice. It's about best practice. If you're just using someone's email address to get a calendar, that's fine. It's what you do with it afterwards. If you then take that email address and you start marketing to that person, you didn't ask their permission, you're in dangerous territory. And yes, it might take a few years for it to come to fruition, but that person could turn around in the same way that PPIs happened, 20 years later. That person could turn around in 20 years and say, look, I just gave Ankush my email address as a calendar opt-in, and he started marketing to me. It's like, the floodgates will, I'm sure, open when people say I was wronged because I was affected mentally because of it. And by then, obviously, the principles will be, everyone will know about it and says, I'm sorry, but that's not true. You, in the court of law, you cannot actually be wronged by someone else's actions. It has to be your thinking. Therefore, you are liable and you are responsible. Case dismissed.
One day. Well, no, that's great because you're right, because I don't do that. I think it's almost like using a bit of common sense. I wouldn't, if I ask someone for someone's email address so I can put in a confirmation of calendar request, I then don't do anything with it. It stays for that purpose.
Having said that, if you have them as a potential client, you're missing a trick if you don't say to them, it's like, I've got all this really juicy stuff. Come on my list. That's
just asking it up front. That's what it is. It's not being underhand or devious or anything else like that.
Now, this is interesting because I got in hot water once because I had all my LinkedIn contacts, and I noticed that you could export my LinkedIn list, and because you have to use this thing called InMail, which LinkedIn's ridiculous, and so I exported the LinkedIn list, and I just sent an email to them, and this was a while back, and I thought, I didn't even realise that was not a good thing to do. So this is before I even understood about the double opt-in stuff. And actually, someone came back to me and they said you shouldn't have done that, but it's actually a very good idea. So this was a while back. But again, it's about being transparent. It's about common sense. Yeah. That's what it is.
Fantastic. Cool. All right. Well, if you've got any more questions for Damian, let us know. Thanks, Christine, for asking those. That's kind of sparked a few things for myself as well. Again, if you're just joining us, Damian's got a list of not an email list, but a checkpoint list of things to consider with regards to GDPR that he's going to send to us, and I can put into the comment section below, so everyone can see that and follow up, or I can even add it actually to the top. I can add it to the comments above in the description of this video, so we can all check it out. So it's just something I wanted to cover. GDPR is coming into effect this week. I know there's been lots of different people saying lots of different things. I've heard you can be, like you said earlier, Damian, you can be fined 4% of your global turnover, or whatever, how many £1 million, and it scared a lot of people. But I think the main takeaway I'm taking from this is be sensible, don't be underhand, and treat people's data how you'd want it to be treated. Do you like being added to Facebook groups? You'd like to be adding to lists, like being added to lists that you didn't join? No. If you wanted to get off a list, would you want to get off it really quickly? Yes. If you want to have your details deleted, would you want to be able to do that? Yes. So I think it's about being sensible, and like you say, it's an opportunity to deepen our relationships with our clients and our potential clients, and be really, really upfront. Which I think, like you say, is it's a very, very good thing, and not something to shy away from or hide from at all. Mm-hmm. So there we go. Any other questions? I didn't know whether this was going to take half an hour today or whether it's going to take an hour. Helen's saying, thanks, guys. Very interesting. Thanks, Helen, for joining us. I'm glad you find it interesting. One question I've got, what if you are a coach who's based in the USA and you've got clients in the EU or prospective clients in the EU? Does this apply to you?
Yeah. Absolutely.
Because it's interesting, I've had all these privacy notice and opt-in requests from European coaches or European lists, but nothing from the USA.
Yeah, if you listen to, it's interesting actually, you listen to some of the American podcasts about this, that they are of the misapprehension that this only applies to companies of over a certain size.
Right.
That are dealing with people, that human beings that are in the EU. And that's not true. It's any data, but again, it's like in 20 years' time, do you really want to still be potentially liable? So if you are dealing with anyone in the European Union as a human being, and you don't have legitimate interest to have their data, and you're using that data in the wrong way, or you're storing it in the wrong way, or doing something with it, or marketing to it in the wrong way, then you are potentially somewhere down the line liable for some sort of action. Just don't do it.
All right, that's useful to know. I'm going to pass that on to coaches that I know in the USA that might have missed this. So that's been really, really helpful. Okay, any more? Any final questions from people before we end up today? If not, I want to thank you, Damian, for taking some time out and sharing with us. It's been helpful. It's been useful for me to get my head around this a bit better, kind of a bit clear around what it means, who's it aimed at, what we need to do, and kind of just a little bit of confirmation around don't panic, just be sensible. And before we finish, Christine's come back in. Sorry, me again. I have a big list of parents I have taught over the years and have their data to contact with class info. Can I keep using this?
So hold on. So what data has she got?
A list of parents to contact with class information. So, Christine, is this kind of names and email addresses of parents that you've taught over the years with their information, with their kids' information, and you've been contacting them? I'm guessing what you're going to say, Damian, is it depends how she got it. Did she ask them, express permission to keep it for marketing purposes? Names, addresses, medical info, and baby names.
Ah, right. No. Well, yeah, you're in slightly dangerous territory there. I mean, that comes under legitimate interests because you've had a contract with them. You've done some work with them. But the question would then be, why are you holding on to their data? If the contract has come to an end, why are you still holding on to their data, and what are you doing with that data? So if it's sensitive information, you should not have it. Yeah. If it's just their name and address and email address as potential future clients, that's legitimate. right? You would have a backup for that. So if you've got data, I mean, I don't know why you would have necessarily medical records, but that data is, unless there's a reason for you to have it, I would get rid of that.
So would a potential next step for Christine to be to take the data, get rid of the medical information and baby names, and then contact the list again and just say, hey, everyone, I've got your information. I've deleted all the medical information and baby names out of this, but I'd like to keep it because I want to stay in contact with you. Are you okay for me to stay in contact with you? And then anyone that says yes, keep, and anyone that doesn't say yes, delete it.
Yeah, that would be very sensible.
Okay, Christine, I hope that helps. I hope that answers the question. That's been really useful for me actually as well. I feel like I've learned something. I'm able to answer that question because at the start of this webinar, I don't know if I would have been able to advise on that, Damian. So that's useful.
But it also does ask the question is like, well, how does she collect the data in the first place? Because if you had the right, because if you're getting sensitive data in the first place, then you would probably have had a privacy notice, for instance. Yeah, so if you're collecting medical records, you would have had a privacy notice saying, I'm not going to be sharing this with anyone. This is for this particular purpose. I'm not going to do anything else with it. That's a privacy notice. Did you have a notice saying that you have a right to alter or delete that? Probably not, because that's a new GDPR thing, right? That hasn't been there before. And who's the person to complain to? So those are the bits which probably makes it non-GDPR compliant.
Okay. No, thank you for that. That's very helpful. And again, Christine, thanks for all the questions, because there are people who have not been able to join us live, but they will be watching the replay, and your questions are going to be really helpful for other people that might be in a similar situation, and help with that. Damian, if anyone's watching this on the replay, or even if they're watching it now and they've got a question and they remember afterwards, or on the replay they remember, can they contact you? And if so, how can they do that?
So if you go to rethinkingbusiness.biz, and just use one of the contact forms there. There's actually the GDPR page is rethinkingbusiness.biz/GDPR, and you can actually sign up for that form there. But then you can contact me at Damian with an A, Damian at rethinkingbusiness.biz. And just to clarify, again, I am not a lawyer, and I am not. There is actually no qualifications in the GDPR as such yet. But as I say, even the lawyers are going to be arguing about this. So, so if you are a bigger business and you need, for instance, a data protection officer that's going to deal with this, and you need training, then speak to a company that is working with the ISO, for instance, that that they recommend.
Fantastic. In one final question, in the one sheet you've got for us, have you got any examples of what an audit trail looks like? How do you actually keep that?
It's not on the one sheet, but again, it's just being sensible. It's about using common sense. Yeah. Okay. So if you go and stick things on USB drives and leave them in taxis, it's not going to go well. Yeah. If you've got things backed up to the cloud, if you've got proper backups, if you don't print things out and leave them places, it's common sense. It's basic common sense. But as I say, if you're dealing with medical records, you're going to have to start looking into getting a data protection officer that deals with this, and certainly training that just shows that you are, if you have an email trail, for instance, that shows that you've told all staff what GDPR is, what they have to do, what to make them compliant, that's an audit that will serve you in years to come if someone comes back and complains. If you show that you're making an effort to be compliant, that's the whole point.
Alfredo says, I will opt in for your newsletter. I don't know if that's yours or mine, but thank you, Alfredo. I've got 4 different lists. So one for coaches, one for my podcast, one for my men, and a general one. So thank you if you opt in for any or all of those. Yes, you can probably check out Damian's information on his website. Thank you so much once again, Damian, for joining us today.
Absolute pleasure.
Really appreciate it.
Thanks for having me.